Hi everyone, welcome to SQE1 window. We look at chapter 8, last chapter of landlord discussion, remedies and enforceability of leasehold covenants. So in this chapter, we examine what happens when lease obligations are breached and how covenant enforceability works when leases or reversion are transferred. So, understanding remedies and enforceability is essential for advising landlord and tenant, and of course for our SQE1. So, leasehold covenants can be negative or positive and are enforceable between landlord and tenant. When breaches occur, parties may resolve them through court action or other remedies. This chapter covers three main areas. First, remedies available for breach of covenant, including non-payment of rent and breaches for other obligations. Second, enforceability of covenants when leases are assigned or diversions are sold. Third, the critical distinction between old leases created before 1st January 1996 and new leases created on or after that date. The 1996 date is crucial because the Landlord and Tenant Covenant Act 1995 fundamentally changed how covenant liability works. Understanding this distinction is essential for analyzing enforceability problems in SQE1 assessment. So it is highly tested and highly challenging area of understanding. So bear with us and we will try to make it easy for you. So when tenants fail to pay rent, landlord have several remedies. Let's examine the main options. First, rent deposits provide security. So landlords typically require deposits for 3 to 6 months. So 3 to 6 month rent. So that is with the landlord to protect them. So the deposit secures the tenant's obligation. If rent is paid, the landlord can draw on the deposit. So if rent is not paid at that point, they can use the deposit, to put it simply. So legally, rent deposits act as charges over money held by the landlord. The balance is returned to the tenant at lease end if all obligations have been met. Rent deposits are common in commercial leases and provide immediate security without court action. That if tenant is not paying, you deduct it from the rent deposit or you take the deposit. Second, action for debt allows landlord to sue for unpaid rent. For example, if it cannot be covered by deposit or there is no deposit. The Limitation Act 1980 sets time limit for leases made underhand. The limitation period is 6 years. For leases made by deed, it's 12 years. These periods apply to both rent and service charges. Limitation period run from when the debt became due. If rent is payable quarterly, the period runs from each quarter day. So landlords must sue within the limitation period or lose the right to recover. Third, insolvency proceeding may be appropriate for substantial debts. If debt exceeds £5,000 for individual or £750 for companies, the landlord can serve a statutory demand. If the debt remains unpaid for 21 days, the landlord can petition for bankruptcy or insolvency. So we need to understand 5,000 for individual and 750 only for companies. So insolvency is a serious step with significant consequences, but it may be necessary when other remedies fail and debts are substantial. So commercial rent arrears recovery, CRAR, that is self-help for commercial leases. So CRAR is a powerful self-help remedy for commercial landlords. It replaced the ancient common law remedy of distress. So now CRAR allows landlord to instruct enforcement agents to seize and sell the tenant's goods found on the premise to recover rent arrears. For example, you got like machines or anything inside, they can sell them to recover the rent. This is a self-help remedy requiring no court order, thought strict, it is strict, but there are procedures that need to be followed to use CRAR. So CRAR applies only to commercial leases that are in writing. The areas must be at least 7 days old. The amount recovered can include rent, VAT on rent, and interest, but not service charges or other sums. So important limitations apply. CRAR cannot be exercised after the lease has expired. It only operates during lease term. Additionally, if premises are sublet, the landlord may apply to court to have rent from the subtenant paid directly to head landlord instead of to the tenant who is at default. So CRAR provides quick recovery without litigation cost, making it attractive for commercial landlords dealing with rent areas like at that point. Forfeiture for rent. Forfeiture is the most serious remedy. It terminates the lease entirely for breach of covenant. For non-payment of rent, forfeiture is relatively straightforward but subject to important protections. Forfeiture requires an express forfeiture clause in the lease. Without such a clause, landlord cannot forfeit. Most leases include forfeiture clauses triggered by specific breaches, including non-payment of rent. For residential leases, significant restrictions apply. Section 81 of Housing Act 1996 requires court order for residential possession. Section 167 of the Commonhold and Leasehold Reform Act 2002 imposes additional procedural requirement for long leases at that point. So relief from forfeiture protects tenants who can have remedy against breaches. If the tenant pays all areas and the landlord's cost everything, the court has discretion to grant relief, allowing the lease to continue. Relief is designed to prevent forfeiture being used oppressively when tenants can and will pay at that point. If they can just make sure that we will be paying at that point, forfeiture cannot be applied because it is very strict. Courts balance the landlord's right to enforce against the tenant's interest in retaining the lease, particularly where the breach can be remedied and the tenant has acted promptly. So, other remedies that we got here: breaches of covenant other than rent, such as repair obligation or use restriction, have different remedies available. Like contractual damages, compensate landlords for loss caused by breach. For repair breaches, Section 18 of Landlord and Tenant Act 1927 limits damages to the diminution in the reservation's value. So Leasehold Property Act 1938 provides additional tenant protection for certain repair breaches, requiring landlord to follow specific procedure. For example, Yavier versus Harris clauses. So that allows landlord to enter premises, carry out repair themselves, and recover cost as a debt rather than seeking damages. This provides a practical remedy, ensuring repairs are done without waiting for court proceeding at that point, and this protects property as well. Another thing is injunctions, and injunctions are equitable remedies that prevent or restrain breaches. If a tenant is using premises in breach of a use covenant, the landlord can seek an injunction to stop the breach. Injunctions are discretionary and granted where damages would be inadequate. So, specific performance is also one of the remedy, and it enforces positive obligation where damages are inadequate. The court can call for specific performance. So we got a case that is Rainbow States Limited. So from 1998 confirms that specific performance can compel tenant to perform repair obligation. For example, they had a repair obligation and they are not doing it, court can order it. Forfeiture remains available for breaches of other covenants subject to stricter requirement than for rent arrears. So what is forfeiture process? Like how it starts? So forfeiture for breaches other than rent follows very strict procedure with important safeguards, as we said. Number one, peaceable entry or peaceful entry allows landlord to physically retake possession by changing locks provided no force is used. This is permitted for commercial premises but extremely risky and rarely recommended. So at that point, it can just start new complexities. Court's orders are mandatory for residential eviction. Under Protection of Eviction Act 1977, landlords must obtain possession order before evicting residential tenants. For commercial premises, court proceedings are prudent even if not legally required. So, waiver of breaches is critical. If the landlord accepts rent or otherwise treats the lease as continuing after learning of the breach, they waive the right to forfeit at that point. The case of Central Estates Limited from 1972 established that accepting rent with knowledge of breach waives forfeiture right. Like, you have accepted, you have condoned it, like, you want to go with it. So Section 146 notice is another remedy, and those are required for breaches other than non-payment of rent. The notice must specify the breach, require remedy if possible, and require compensation. The tenant must be given reasonable time to just put things right at that point before forfeiture. So Section 146 procedure protects tenant by ensuring ensuring they know what breach is alleged and they have an opportunity to put it right. So the next thing is subleases. Let's talk about it, how it affects forfeiture affects subleases. So forfeiture of a head lease destroys any sublease carved out of it. This creates potential injustice when subtenants have done nothing wrong but lose their interests because of the head tenant's breach. So Section 146 subsection 4 of Law of Property Act 1925 provides some sort of protection. So subtenants can apply for relief from forfeiture of the head lease. The court may grant a new tenancy directly from the head landlord to the former subtenant. The case we got we got a case that establishes that a relief term should reflect what remains of the original unexpired term. So original unexpired term will continue. So new lease created by the court essentially continues the subtenant's occupation, but now directly with the head landlord, and the person at default is, gone between them, or they are minus. So this protection ensures subtenants are not unfairly prejudiced by action of immediate landlord over whom they have no control. So there are other ways of termination. Number one, expiry of time. The natural expiry, lease was for a time and that is gone. Number two, it is a break clause, that the lease had termination or break clause in it. So at that point, one of the cases established that break clause condition must be strictly complied with. If the clause requires vacant possession, the tenants must actually deliver vacant possession, not merely offer it. So sometime there is surrender, the lease is surrendered. So express surrender requires a deed. Implied surrender by operation of law occurs when parties demonstrate that they want to surrender the lease. For example, the tenant returning keys and the landlord accepting them and reletting. So that's surrender of lease. Merger occurs when the lease and the reversion vest in the same person with no immediate interest, that it was on lease and freehold has been bought by the tenant. At that point, both titles or both estates merged into same person. So tenant remedies. Tenants also need remedies when landlord breach covenant. For breach of the covenant for quiet enjoyment, for example, tenants can claim damages for interference with possession and enjoyment. Injunctions may prevent continuing interference. Quiet enjoyment does not mean freedom from noise. It means freedom from substantive interference by the landlord. For repair obligation, Section 17 of the Landlord and Tenant Act 1985 allows tenant to seek specific performance, compelling landlords to carry out required repairs. This is very important for residential tenants who may not have recourse to repair and sue for damages. So residential tenants have strong statutory protection. The protection from Eviction Act 1977 makes unlawful eviction, and also it makes eviction a criminal offense at some point. So unlawful eviction under Eviction Act 1977 is a criminal offense. For assured short hold tenancies, Section 21 notice must comply with the strict requirement before landlord can obtain possession. So it's a bit hard to evict residential tenants. So commercial tenants with protected tenancies under Landlord and Tenant Act 1954 have security of tenure and rights to lease renewal, they can renew it at the end of tenure. These protections balance the landlord-tenant relationship by ensuring landlords also face consequences for breach. So now let's look at two different regimes. We got old leases pre-1996 and then leases, those are in 1996. So old leases are those created before 1st January 1996. So anything in 1995 and before, they are governed by common law doctrine of privity of contract and privity of estate. So privity of contract means the original landlord and original tenant remains liable on all covenants throughout the lease term, even after assignment. If the original tenant signed the lease and the assignee defaults, the landlord can sue the original tenant who remains contractually bound under privity of contract. This creates significant complexity. Original tenants may remain liable for breaches occurring years after they assigned, committed by assignees they have never met in their life. This is harsh rule created commercial problems, particularly for original tenants of long leases. 999 years, you have sold it, and someone knocks your door after 70 years, or you get some notice after 70 years. So privity of estate governs liability between current landlord and current tenant, that is between estate in the land. So only covenants that touch and concern the land are enforceable under privity of estate. The test from Spencer's case in 1583, very ancient case, requires covenants to affect the landlords and the tenant, not personal covenants, anything that is attached to the land. So indemnity covenants are commonly required on assignment. When the original tenant assigns, they require the assignee to covenant to indemnify them if for any future breaches, if someone comes after 70 years, you have already indemnity from someone. So this creates a chain of indemnities through enforcing against remote assignees. So that may be difficult. So understanding all lease rules remain important because many pre-1996 leases continue in existence. So understand leases before 1996, privity of contract applies and privity of estate, both of that applies. But the new thing that is post 1996, so new leases are created on or after 1st January 1996 are governed by the Landlord and Tenant Covenant Act 1995, which fundamentally reformed the law. The act abolished privity of contract for new leases, no privity of contract. The original tenant is automatically released from covenant liability upon assignment, unless they enter an unauthorized guarantee agreement, an authorized guarantee agreement, AGA. See, so the assignee inherits the burden of all tenant covenants from the date of assignment. They become liable for all future breaches. When they in turn assign, they are released and the new assignee becomes liable. This creates a cleaner system where only the current tenant is liable. It eliminates the unfairness of original tenant remaining liable indefinitely. The same principle applies to landlord covenants. When the reversion is sold, freehold is sold, at that point the new landlord becomes bound by all landlord covenants. The former Landlord may apply to release under Section 6 to 8 procedure. So Authorized Guarantee Agreement, AGA, known as AGA, that's a different concept. It allows landlord to require a signing tenant to guarantee their immediate assignee to the next assignee. The AGA makes the assigner liable only for the immediate assignee's breach, not for everyone in the chain. So AGAs cannot be required automatically. Whether consent to assignment can be conditioned on providing an AGA depends on lease terms and whether it's reasonable in circumstances. So the 1995 Act balanced landlord security against tenants' fairness, creating more equitable allocation of risks at that point. So not a long chain now. So you can just assign it and release yourself. And if there is guarantee required, you just give AGA to immediate person to whom you are assigning. That's it. So the next thing is assignment and reversion. When tenants assign leases and landlord sells reversion under the 1995 Act regime, specific rules govern liability transfer. On assignment by the tenant, the assignee becomes liable for all tenant covenants from the assignment date. The assigner is released automatically unless an AGA is in place. So authorized guarantee. If there is an AGA, the assigner guarantee only the immediate assignee, not the future assignees. On sale of reversion, the new landlord takes on all landlord-tenant covenant. At that point, the Act provides a procedure allowing former landlords to apply for release from continuing liability. If the tenant does not object within prescribed time limit, the release is automatic. So indemnities are not applied in new leases. Under old lease law, indemnity covenant were implied by statute on assignment. The 1995 Act removed this. If the landlord want continued protection beyond the immediate assignee, they must require express AGAs. This shift places more emphasis on due diligence when accepting assignees and on properly drafted AGAs where continuing security is needed. So, former tenants and guarantors. So there is restriction on liabilities of third party. So even under new lease, landlord may sometime pursue former tenants or guarantors, subject to important restrictions. Section 17 of 1995 Act protects former tenants and guarantors by requiring landlords to serve notice within 6 months of any sum becoming due. Without timely notice, former tenants and guarantors are not liable for that breach. This prevents landlords from allowing arrears to accumulate for years and then pursuing original tenants for massive sums. The 6-month window ensures former tenants have notice of problems while they are granted. So Section 19, subsection 1 of the 1995 Act gives former tenants or guarantors who pay sums demanded an important right. They may require no overriding lease, a lease inserted between the landlord and the defaulting tenant's lease. This makes them the immediate landlord and gives them control, including the right to forfeit the defaulting tenant's lease. So overriding leases protect former tenants who are forced to pay by giving them property right and ability to remedy the situation rather than merely suffering the loss. So let's talk about head landlords and subtenants. That is privity and enforcement. So head landlords generally have no direct privity relationship with subtenants. There is privity between head landlord and tenants, and between tenants and subtenants, but not directly between head landlord and the subtenant, the subsequent tenant. This means head landlord cannot directly enforce covenants against the subtenant. However, several mechanisms provide indirect control. The Contract Right of Third Parties Act 1999 allows enforcement of covenants by third parties if the contract expressly provides that they may enforce, or if the term purports to confer a benefit on them. Subleases can include clause giving head landlord direct enforcement rights. So alternatively, subleases commonly require subtenants to directly covenant with the head landlord to observe head lease covenant. So this creates a direct contractual privity. Break clauses in the head leases may automatically terminate subleases. So in case we got it, confirm this principle. Subtenants must therefore be aware of break right in superior leases that could affect their interest. So understanding these relationship is important, although it is very complex, but of course it is very important to understand once you go to SQE exam. And this is one of the challenging areas of land law. For SQE tips, first and absolutely critical, distinguish between old and new leases. Check whether the lease was created before or after 1st of January 1996. This determines which enforceability rules apply. Old leases involve privity of contract and continuing original party liability. New leases involve release on assignment subject to AGA. Getting this wrong means applying the wrong rules and of course losing marks. Second, know all available remedies. So rent deposit, action of debt, insolvency, CRAR. For commercial leases and for features at that point, everything you need to, CRAR for commercial leases we got it, and for feature for commercial leases we got both these remedies. So each has different requirement, advantages and limitations, and you need to know which one to apply. Third, you need to understand for feature comprehensively when you can do it and rights against for feature. Understand. Fourth is you need to understand assignment and sale of reversion thoroughly. The new leases assigner are released automatically on assignment unless they have given AGA. The old leases original parties remain liable throughout. When advising on assignment, consider whether AGA are required and enforceable. So fifth, remember the impact on subtenants. Forfeiture of head lease destroys sublease. And you need to understand under section 146 what relief is available. You need to understand break clause may terminate sublease, and you need to understand the hierarchy of lease. 6, you should know tenant remedies against landlord. These are often overlooked, and you need to have a quick grip on it. 7, understand section 17. Notice requirement for pursuing former tenants and guarantor under new leases. Landlord, under new leases. So landlord must serve notice within 6 months or lose the right to recover what they have lost. So I hope this helps you all. And of course, this lease kind of thing is a bit complex in this part of the world under British common law. But of course, it creates certainty, it avoids litigation, it is thorough, but at that point, once you follow it, you avoid load of dispute. So thank you very much for attending today, and I wish you all the best. If you share this, if you learn anything, I request you to subscribe and share it with your friends. Ta-ra!